Hi, everybody. I'm Brian T. Bradley, and I'm an asset protection attorney. And today's quick tip is on the importance of jurisdiction, especially when setting up your asset protection system and really getting the best home field advantage that you can. Jurisdiction here is probably one of the most important concepts in asset protection besides maximizing exemption planning. And what we mean by jurisdiction is that the laws and the rules that govern you and your trust are going to be different in each state and even in each country. These differences are going to have a huge effect on how safe your assets really are. Are you going to have real safety, or is it going to be a false sense of security? It's that important. This really is the offshore advantage. Not all states domestically in the U.S. have favorable asset protection laws or judgment order laws, and only a few states that we deem asset protection friendly states are going to even have self-settled spendthrift legislation. And even in these friendly states, the hallmark of the U.S. legal system isn't going to be in your favor. Anything purely domestic fails simply because of the hallmark of the asset protection system. The hallmark is to not recognize another jurisdiction's court orders. Yet the framework or hallmark of the U.S. legal system is the U.S. Constitution. And the U.S. Constitution under Article 4, Section 1 provides that every state must grant the full faith and credit of another state's judicial proceedings. You can't run from U.S. judgments is what this means. The greatness of a foreign asset protection trust is that it statutorily has non-recognition of any other jurisdiction's court orders. What this means is that your U.S. judgment in the U.S. is completely worthless in the Cook Islands, for example. You would have to start your case all over if you were being sued. The plaintiff would have to start their case all over from scratch, facing the highest legal standard in the world, the murder standard, beyond a reasonable doubt, the highest possible legal standard. The claim is not amendable, meaning that once they file the claim, that's it. The complaint can't be amended after the discovery process, which is a common tactic in the US. If you lose, you pay. And so with a burden of proof beyond a reasonable doubt, whoever's attacking you is almost certainly going to lose. And so they're going to be paying your legal fees also. And the statute of limitations has most likely already run, since the Cook Islands has a 1-year statute of limitations. Basically, before they even take a shot at swinging at you in the Cook Islands, they've already missed their chance. And now when talking about fraudulent transfers in jurisdiction, this is where the importance of jurisdiction also really comes into play big time. A fraudulent transfer is a transfer of an asset made for little or no consideration, where the other party didn't really get anything of value in return for it, with the intent to hinder, delay, or defeat the claim of a creditor. Now, a fraudulent transfer, unlike fraud, isn't per se a crime. Fraud is a crime, but fraudulent transfer is really just what's called a supplemental or secondary proceeding, where you get sued. They start finding out what assets you have and what assets you transferred. And if you're discovered to have made a transfer for little or no consideration within a certain amount of time, generally within about 5 years of the lawsuit, the other party is going to ask the judge to undo the transfer. And the remedy is just to undo the transfer, meaning to give the asset back to the trust so that they can then get access to that asset. The reason an offshore trust is so powerful in this regard is that in order to undo the transaction, the court has to have the power to tell that person that you did the transfer to, the person that you gave the asset to give it back. And so any court in the U.S. does not have the power to tell an offshore Cook Islands trustee what to do or even to give the asset back. The Cook Islands statutorily do not recognize any U.S. court order or judgment. Now compare this to anything in the U.S. Any system that's purely domestic in the US doesn't have the ability to say no. And this is because of the full faith and credit clause of the Constitution. That's the power of going offshore. And we can even bridge the two together with what we call a bridge trust. And then you have the flexibility of a domestic asset protection trust and not have to file foreign asset protection trust IRS tax filings, because at the moment you're domestic. And then once the trust is triggered with an event of duress, like a lawsuit, we just cross the bridge into the Cook Islands and the safety of the Cook Islands when and if you ever need it. And so thanks for listening to this quick tip and learning about asset protection and the importance of jurisdiction when you're thinking about setting up your asset protection trust. And I hope this has been helpful and that it helps you find the best home field advantage. And you can reach me. My email is Brian, BRIN, at btblegal.com, or you can jump on my website at www.btblegal.com. And again, thanks and take care.